Today we have two excellent speakers and friends, comrades, and our first speaker is Charlotte Cates. Charlotte is an attorney and an activist. She works for the Center for Constitutional Rights in New York, and she's active on the education front of the campaign to close and shut down Guantanamo.
Coming from the United States, as I do, in a lot of ways, Canada has been seen by the U.S. and treated by the U.S. government as sort of a junior partner in the so-called war on terror that it has been waging. And of course, you know, U.S. imperialism is nothing new. This is a historical moment. It's not that the U.S. before September 11th, 2001 never engaged in invading other countries, racist repression at home and abroad, exploiting countries for their natural resources, propping up puppet regimes and toppling other regimes. It's not that this is behavior that's new. And it's not that the age of the U.S. empire dawned on September 12th, 2001. However, the phase of the war on terror, the so-called war on terror, has really provided a new opportunity for U.S. imperialism to raise its level of repression and to do so in a way that is overt and public and perhaps unprecedented in the extent to which it is overt and public. The rapacious, assault of U.S. imperialism following September 11th that's taken on the name of the War on Terror, which, replaced the so-called Cold War, which preceded it, is the kind of policy that could only take place in the seemingly unipolar world of in the kind of seemingly unipolar post-Soviet world. And what we're seeing today, now in 2008, is clearly a break in the idea that the United States is the sole great power in the world today. And looking at the vast increases and challenges to U.S. power from Latin America, from Venezuela, Bolivia, and elsewhere, looking at the continued failure and lack of success of the United States in Afghanistan and Iraq and elsewhere, looking at the financial crisis in the United States right now, and simultaneously at the growth of China's economic power, which is quite visible in any discussion of the economic crisis in the U.S. right now, and also at the resurgence of Russia in terms of asserting its willingness to be an alternate force, not necessarily because of its commitment to anti-imperialism or standing for social justice, but simply because the United States has paid little to no regard for the concerns of Russia, and the only way for Russia to secure its own interests in the quote-unquote war on terror world is to take its own position and redefine itself in a position of power. But the so-called war on terror in many ways took on two key prongs. There was the racist repression and war on terror at home in the United States, which has been in many ways mimicked in Canada as well, and also the war on terror abroad, which we've seen in Afghanistan, in Iraq, and elsewhere. And one of the key features of the U.S.'s war on terror abroad, and also its war on terror at home, has been the assertion of the United States government's power to detain anybody at any time, anywhere around the world, and hold them without charge, without trial, and without accusing them of any recognizable criminal offense. The old categories of criminal imprisonment, of arrest and prosecution of prisoners of war have been discarded and replaced with a new term of detainee, which covered thousands and thousands of immigrants swept up in raids in the United States following September 11th, and also includes thousands and thousands of men and women held in Iraq, and also includes the hundreds who remain today at Guantanamo Bay. And this term of detainee has come to mean, in a sense, although there are legal processes, particularly for immigration detainees and otherwise, the one who has little to no real protection in the legal system in the United States. In fact, being a detainee has become a sort of a mechanism to exist outside the law as it existed at the time of the inception of the so-called War on Terror, and replace it instead with a new paradigm in which anything could be justified in the interests of fighting terrorism. In the opening of the prison camp at Guantanamo Bay, I mean, these images that were broadcast around the world, the barbed wire, shining in the sun, the men hooded with the black hoods and goggles, in orange jumpsuits in Cuba in cages. These were the images that the world saw, and this was the United States openly asserting its right to pick human beings up halfway around the world, throw them in another territory, throw them in another country, not even the United States, and cage them with no potential of charge, trial, or release at any time. And these images of Guantanamo sparked massive outrage around the world. Yet, nevertheless, here we stand nearly 7 years after the opening of Guantanamo Bay, 6.5 years after the arrival of the first prisoners there, and over 270 men still remain imprisoned at Guantanamo. And since the first day that prisoners arrived at Guantanamo, there have actually been legal challenges to the use of the base as a detention center. The first challenge was filed only weeks after the first prisoners arrived. Several of those that were brought as in the first group of detainees to Guantanamo from Afghanistan were citizens of the UK and of Australia, whose families had contact with UK and Australian and U.S. attorneys who filed habeas corpus claims. And basically, a habeas corpus claim is seeking one's right to have a fair hearing before a real judge to determine whether or not the government has the right to detain you. And essentially, oftentimes, habeas corpus hearings are not overly successful for people who bring them against the government. In fact, it's kind of a last-ditch attempt to secure some measure of justice. However, in the case of Guantanamo detainees, the U.S. government has been so frightened of any challenge to its authority to hold prisoners that it has fought since 2002 the ability of any detainee to bring a habeas corpus challenge in a court of law. In fact, from Donald Rumsfeld on down, Guantanamo detainees were labeled as the worst of the worst, and as such, they were subject to torture, to endless interrogation, to both physical torture as well as psychological torture. Sleep deprivation, the use of loud music that was played incessantly, the use of cold rooms, what was called the so-called frequent flyer treatment, where one detainee was moved from cell to cell 148 times in I believe, a 60-day period, in order to completely destabilize and disorient these men who had been flown halfway around the world to a secret prison. The United States initially even refused to release the names of the men at Guantanamo. They were supposed to be condemned to remain nameless and faceless, seen only to the world as black hooded men wearing orange jumpsuits with no names, no history, no identity, and no faces. And so it actually took several lawsuits and several Freedom of Information Act lawsuits by U.S. press agencies to force the government to release these names. And to thereby, when releasing these names, each person who's being held at Guantanamo has a story, has a face, has a family, has a community that they've been ripped away from and been taken away from and have left behind. And so for the past 6.5 years, the legal challenges to Guantanamo Bay have been going forward. And the Center for Constitutional Rights, which I work for, is a New York City-based human rights and progressive legal institution that focuses on working with social movements in order to support social movements' work through through legal challenges in the U.S. courts and also in international bodies. the use of, when CCR first filed the first habeas cases on behalf of the three men who later became known as the Tipton Three from the UK, as well as David Hicks from Australia, we couldn't even find one cooperating attorney in Washington, D.C. who was willing to file the papers under their name in Washington, D.C.'s court. No one wanted to be associated with these claims because they saw them as, dangerously close to defending terrorists. And that was the environment that existed in the United States in January 2002. And what we see today in 2008, following the most recent Supreme Court victory in June, in which the Supreme Court for the third time upheld the rights of Guantanamo detainees under U.S. and international law to challenge their detention, we now have over 500 cooperating attorneys providing pro bono legal services from some of the biggest law firms in the United States. From some of the biggest law firms in the United States providing these services basically in order to preserve the rule of law and preserve the United States system. And it's particularly significant to note that both Barack Obama and John McCain have stated that they want to shut down Guantanamo. And shutting down Guantanamo, and this has actually been a victory. The reason why all of this is taking place, the reason why the Supreme Court ruled the way it did, the reason why lawyers are willing to work for Guantanamo detainees now when they weren't in 2002, isn't because they've suddenly developed a concern for the principles of the Constitution. And it isn't because of a sudden realization or a wake-up call on the part of the ruling class in the United States about the legality or justice or injustice of indefinite detention. It's because of the fact that there's been an international movement to secure justice for the men at Guantanamo Bay, and that international movement has taken these images that the United States wanted to send out around the world as a message of its unchallengeable, indestructible power, and showed them instead for what they are, as images of torture and horror and revulsion. And that movement is why today it's almost unacceptable to say in U.S. political discourse or other political discourse that Guantanamo is something that shouldn't be shut down. But no matter who the next president is and whether they shut down the base at Guantanamo or not, that doesn't secure justice for the men who are being held at Guantanamo, and it doesn't end the process and the practice of indefinite detention, nor does it end the so-called war on terror framework. In fact, while Obama and McCain are busy saying that they want to shut down Guantanamo, they're also both discussing how they can step up the war in Afghanistan and even extend it to Pakistan. And they both have discussed various plans for what's going to happen to the men at Guantanamo. What's going to take place with these men? They're going to be moved to either military bases in the United States, secret facilities around the world where the CIA has been holding prisoners for the past 6.5 years as well, or they're going to be shipped to proxy facilities in Afghanistan, the Horn of Africa, and elsewhere. They're nominally governed by the home country, however, have national security funding, advice, and authority from the United States government, as well as U.S. contractors like Blackwater, Khaki Titan, L3, and others. And I just wanted to note in particular the case of Omar Khadr, being that this is a Canadian audience, and to note Khadr's case because it is a unique case in Guantanamo in that he was 15 years old when he was captured. Under any sense of international law, of the Geneva Conventions, of looking at the treatment of prisoners of war, and the Convention on the Rights of the Child, he should be looked at as, at worst, a child soldier. But the United States so-called military commissions have refused to even allow testimony or entrance, or even allow a United Nations advisor who is an expert on child soldiers to even view the military commissions of Omar Khadr. And in Canada, the movement in Canada, for example, the victory in the Supreme Court, in which the Supreme Court ordered the Canadian government to release its interrogation tapes of Omar Khadr, revealing the fact that Canadian interrogators were there at Guantanamo. And rather than securing the release of Omar Khadr, were participating in his interrogation and looking for evidence against him to turn over to the U.S. military commissions. And it's important to note about Omar Khadr's case is that this is quite unique, and particularly for the length of time that the Canadian government has continued to support the detention of Omar Khadr in Guantanamo, and this lawless prison camp that the U.S. is erecting in Cuba. In the British detainees, the French citizens, and all of the other Western citizens that were being held in Guantanamo, even people who held resident status but not citizenship status in the UK, have been freed. And why have they been freed? They've been freed because their governments kept pressure on the United States to free their citizens. And the reason why those governments kept pressure on the United States to free their citizens is because there was a substantial movement within their own countries to stand against what the U.S.'s war on terror paradigm, and certainly to do this by demanding that citizens of their countries not be held in this infamous international torture camp. And even in Australia, where there was David Hicks, who also faced a military commission, just like Omar Khadr. In fact, the imprisonment of David Hicks became a significant issue in the national elections when John Howard, then Prime Minister, supported the ongoing detention of David Hicks and was, kind of roundly criticized for it by many people in Australia. To look at the case of Omar Khadr and to see, some of the reports that are coming out of Canada about weeks of action for Omar Khadr, that being someone who's working on these cases in a legal manner in the United States, it's particularly inspiring and important to see that, because that's the kind of work. It's not our work in the courts that's actually freeing these men. What's freeing these men are the movements in the streets, not just here in the U.S., here in Canada, in the home countries of the men that are being held at Guantanamo, but the international movement against U.S. imperialism, against the so-called war on terror, and exposing everything that means and everything that stands for. Because the image of Guantanamo that shifted from an image of U.S. power to an image of torture and oppression is something that was achieved by this movement. And the freedom for Omar Khadr and the other 250 men being held at Guantanamo is something that can also be achieved by this movement. So I really look forward to discussing further with any of you what's going on here and what we can do in the United States in the movement to shut down Guantanamo, to work together, not just to shut down this prison camp, but to shut down all prison camps like it, and to ensure that these men don't get sent to an even more untraceable location, but instead are able to return home to their families and to freedom and to justice.
Thank you, Kelly. And our second speaker is John Elmer. John is a writer and a journalist specializing in the Middle East and Canadian foreign policy. John is currently co-authoring a book, and he's writing a book about the situation in Afghanistan and also the Canadian role in that context.